Good day, everyone, and hello, everyone. Good day, and welcome to the AA Secretaries webinar series. AA Secretaries we hold webinars bi-weekly, basically, and today we're going to be looking at a very interesting topic: company compliance under CAMA 2020. What every business owner gets wrong. I'm Busari on and I'm going to be the one educating us today. All right, let's get into it. Um, Sorry, I just need to adjust my audio real quick. All right, good day, everyone. Once again, I welcome you once again to the AA Secretaries webinar series. Today, we are going to be looking at a very interesting topic: company compliance under CAMA 2020. What every business owner gets wrong. So just come with me on this interesting journey. Once again, my name is Busari Onopemifo, and I'm going to be the one educating us today on the AA Secretaries webinar series. All right, let's get into it. Company compliance. So a lot of people know that you should register your company, right? I mean, basically, if you don't register, it has no legal existence, no legal validity in the eyes of the law. So everyone advertises that, oh, you should register your company. Everyone knows that, but after registration, most business owners. Now, when I say business owners here, I'm basically referring to companies. Companies are business organizations, right? So basically, when you hear me say business owners here, just that I'm referring to companies. Thank you very much. So yes, for majority of business owners, they think that the journey ends at incorporation. That is upon registration. Oh, I now have my CAC certificate. That's all I need to do. I cannot run my business anyhow I want to. No, that's wrong. Registration just gives you a legal identity, but your continual legal validity is dependent upon compliance, right? So incorporation is the beginning of your legal obligations towards your business, but compliance is too important to be ignored because it can mar the entire existence of the business organization that you have so labored to build. Like I said earlier, registration gives you a legal identity, but compliance keeps you legally valid. All right, if you can see my slide, you see here a table that sort of differentiates between registration and compliance. So registration is a one-time event, compliance is a continuous process, right? So that's why I said earlier, it doesn't just end at registration. After you register your company, you have to stay compliant, and that's a continuous process. Also, registration gives you a CAC certificate, right? However, compliance gives you your active CAC portal status and filed returns, right? Registration gives you visibility in terms of publicly celebrating your business launch. When it comes to compliance, I mean, it's unseen because you're doing it at the back end, right? But it takes discipline and eventually ensures your continual legal validity. And then registration creates legal identity. Compliance will protect you against penal sanctions and administrative dissolution. So you know what exactly is um, company compliance? Yeah, I'll just give us a brief overview. So the major regulatory body for companies in Nigeria is the Corporate Affairs Commission. And the Corporate Affairs Commission does this through its regulatory law, the Companies and Allied Matters Act 2020, which is what we're really talking about today. Now, there are other regulatory bodies, there are other regulatory laws depending on your industry and the company, depending on the industry that your company belongs to, right? So, for instance, we have the Central Bank of Nigeria regulates financial institutions alongside CAMA. We have the National Insurance Commission for insurance companies. Um, we have the Nigerian Upstream Petroleum Regulatory Commission and the Nigerian Midstream and Downstream Petroleum Regulatory Authority, which regulates the oil and gas industry. Also, there are various codes of corporate governance for various industries that you have to comply with. So, these regulatory bodies regulate the industries that pertain to them alongside the Companies and Allied Matters Act, right? So, when you look through CAMA, when I say CAMA, just now I'm talking about the Companies and Allied Matters Act. I'll be saying CAMA a lot because that's not. So when you look through CAMA, it reviews what compliance for companies entails. So we're talking about meeting statutory obligations, keeping proper records, filing required returns, following rules that pertain to your industry as reviewed by the government from time to time. Because sometimes circulars will come out, or CAC will release a circular, oh company, this is what you should now do. You have to comply with that to ensure the continual legal existence of your company. Do you understand? Okay. And then let's backtrack a bit, right? After you register your company, like, okay, now I've registered, what is the first thing I'm supposed to do as regards compliance? There's some basic obligations that you have. First off, you must publish your name and your registration number conspicuously, that is obviously at every of your office locations. So it should be on your business letters, on your letterheads, on your advertisements, and on every official publication that is released by your company. If you fail to do this, you and the officers in your company will be liable to penalties. You can verify this information from CAMA yourself. Section 729 of the Companies and Allied Matters Act has this. There are also some things that are peculiar to industries. I already said it earlier that there are some regulatory bodies that regulate peculiar industries. There are also some compliance obligations that are peculiar to some industries. For instance, if you're a financial institution, you must file your statement of affairs before you commence business. And you must also do this continually every first Monday in February and every first Tuesday in August. There are penalties like with this. Alright, so let's get into it. If you can see my slide, you'll see that we're starting with statutory books and records. I just said the things I said to give us like an overview and bring us up to this point. So we're going into some key compliance obligations that companies have to observe basically. I'm going to start with statutory books and records. Now, there are statutory books that CAMA mandates companies to keep. Examples, we have register of members, we have index of members. Now, index of members is not required for all types of companies. So, okay, I should have said this earlier, but it's not too late to say that these compliance obligations also are customized depending on the kind of company that you operate. That is the status of your company. Is your company a public company, a private company, a small company? Yeah, like that would matter. So, as I was saying, the statutory books and records, I was talking of index of members, and I was saying that um, if you're a public company and you have more than 15 members, then you need to keep index of members. Other statutory books and records are register of substantial interest in shares. You have to keep a register of directors. You have to keep a register of directors shareholding, register of secretaries, minutes books, accounting records, amongst others. Now, you're supposed to keep these statutory records at the registered office address of your company or at the designated address that you're choosing as your company's address. The Corporate Affairs Commission can come to inspect these registers, and you should not have informal records of them, or you should not be unable to produce them when they are required for inspection, else you'll be liable to penalties. Okay, so next we'll look at communicating changes in your company, right? So like basically notification window. CAC needs you to be accountable, right? So every internal change in your company structure or operations ought to be communicated within such timeline as is required by CAMA. That's why you see here on this slide, you see that I gave some examples of some changes that you would need to notify CAC of. CAC is Corporate Affairs Commission. I've said that earlier, right? There are some changes that you need to reply to inform CAC of, and there are designated days. So the days are not uniform. That's why you can see here X days, because it differs. For instance, if you effect any change in your directors or in the details of the directors, you should inform CAC within 14 days. Same goes with that of secretaries and their details. You should inform CAC within 14 days. Then if you alter any change anything in your memorandum or association of articles, perhaps you change your name or you increase your share capital, you reduce your share capital, you subdivide it, whatever you do, basically, any internal change you make, you're supposed to notify the Corporate Affairs Commission. All right. It is also worthy of note that there are procedures for these alterations. You should follow it. That's part of compliance as well. So, for instance, you want to change your name. CAMA tells you how to do it. In section 30 of CAMA, you see there, it tells you how to do it. You should not now just arbitrarily wake up on Monday, maybe the director just wakes up and decides to change the name of the company. No, there's a procedure to follow, and you have to comply with that procedure for the change of name to be valid. So if you effect such changes without following the procedure or do them without informing CAC, the company, directors of the company, the officers of the company will be liable to penalties. Okay, let's go on. Very important. Notice of persons with significant control. The PSC here means persons with significant control. A person with significant control is anyone who directly or indirectly owns at least 5% of a company's shares or voting rights, has the right to appoint or remove directors, or otherwise exercises dominant influence over the company. Now, companies must disclose individuals who exercise significant control or influence over them, whether directly or indirectly, right? Sections 119 and 120 of CAMA 2020 provide that companies must notify CAC of persons with significant control within 1 month of becoming aware, and companies are to maintain a register as well. So, we spoke about statutory books and records earlier. One of the registers that um, companies are expected to keep is the register of persons with significant control. Okay, next we're going to be looking at meetings. Yes, there is also compliance obligations that companies have to fulfill as regards meeting. Now, recall that earlier I already said that some of these compliance obligations are customized to the status of your company. So, for instance, if you are a public company, if you're registered as a public company, then you must hold a statutory meeting within 6 months from the date of your incorporation. This is according to Section 235 of CAMA. Your statutory meeting should be held in Nigeria, and there must be at least 21 days notice of meeting. That is, you inform the members that will be at that meeting at least 21 days before the meeting holds, except there's an exception to this, except 5% of members agree otherwise. It is imperative to note that the Business Facilitation Act of 2023 now allows public companies, private companies were always allowed, but now public companies also to hold statutory meetings electronically, right? Now, also have annual meetings. Every public and private company is mandated to hold annual general meetings. Now, small companies are exempted from holding annual general meetings. What is small company? If we look at section 394 of CAMA, a small company, there are some features that are given there. So if a company meets these features, it can be identified as a small company. So first of all, it's a private company. So a public company cannot be a small company. First, this is a private company. If its annual turnover is not more than 20 million naira, or such amount as may be fixed by the commission from time to time. So this amount can vary. Also, a company will be identified as a small company if its net asset value is not more than 60 million naira. These amounts may also vary from time to time, that is, the commission can upgrade or degrade the amounts as situation demands. Also, none of the members of the company must be an alien, or rather should be an alien for the company to qualify as a small company. None of its members should be a government official, government to be like government rather, or government corporation, or or government agency, government nominee, no connection with government basically. And if it's a company that has a share capital, the directors between themselves should hold at least 51% of the equity share capital of the company. That's I just said that to help us identify what a small company is. Now back to what I was originally talking about for annual general meetings. I was saying that a private or a public company must hold annual general meetings. Now, your first annual general meeting should hold within 18 months of incorporation. So, you register your company today. Within 18 months from the date that you obtain your CAC certificate, your incorporation status, you should hold your annual general meeting. Then, subsequently, 15 months should not elapse between one annual general meeting and the other. Although CAC, if you apply to CAC, they might grant you a 3 month extension such that 18 months will eventually allow between one AGM and the other. But generally, 15 months is the um, limit that CAC gives you, um, between which you should hold your annual general meetings. Now, at every annual general meeting, the financial statements, the directors and auditors report must be presented. 21 days notice of meeting is also required for annual general meetings, and failure to give members notice will invalidate the meeting, except where all the members unanimously agree to receive shorter days notice, then the meeting can go on. Okay, we also have um, board of directors meeting. Yes, so we'll find the details concerning board of directors meeting in section 89 of CAMA. The first meeting of the directors also has to be held within 6 months, excuse me, within 6 months of incorporation. Subsequently, any director or secretary can, or through the secretary, can summon the meeting of the board of directors. Now, there are other meetings such as extra ordinary general meeting, court ordered meetings, but these ones will come up when necessary, right? So there aren't timelines for them. I see. Okay, next, let's move on. Now we are looking at the matter of directors. There's a lot to unpack the issue of directors when it comes to compliance with CAMA. Right. So first of all, who's a director? CAMA defines a director, right? So the director is someone who is duly appointed by the company to direct and manage the affairs of the company. Now, what do we mean by due appointments? If we're talking about first directors, then they must have been appointed in writing by the subscribers or in the memorandum and articles of the company, or a majority of them, right? Um, that's we can find that in section 269 of CAMA. Also, they must have been named in the articles of the association of the company. That's if you're going to be first directors. But for subsequent appointments, they must have been appointed in the general meeting of the company by passing a resolution. So you can't appoint directors arbitrarily or anyhow. You have to pass resolution. Um, Now, by virtue of section 271 of CAMA, every company that is public and private must have a minimum of two directors, with the exception of small companies. So a small company can have one director. The maximum number of directors is to be determined by the articles of association of the company. Now, every director or member who is aware that the company carries on business with less than two directors after 60 days, when the number has fallen below two, will be held liable. So the requirement that for a public and private company, not being a small company, must have at least two directors um is a demand basically. It's something that you have to follow. It's compulsory. It's not a suggestion. Yes, that's what I'm looking for. It's not a suggestion. It's compulsory. Now, it's not every person that is qualified to be a director, so you can't just put anybody there. Who can be a director? First, an infant below the age of 18 years. That's the minimum. That's the minimum age requirement. Now, maximum age requirements. Let me explain it this way. There isn't a maximum age requirement per se. However, if you're a public company and you want to appoint a director that is above the age of 70 years old, you must disclose the age of the director you're about to appoint at the general meeting when they're about to pass a resolution for the appointment of director. You must disclose the age. But for private companies, there is no such requirements. That's where the distinction is. Also, a person of unsound mind, a lunatic or a person of unsound mind cannot be appointed as a director. An undischarged bankrupt or a person who has been declared insolvent cannot be appointed as a director. A person that's vacated office, that's if you check section 284 of CAMA, the person who has vacated office under that section cannot be appointed, sorry, excuse me, as a director. And fraudulent promoters that have been banned for 10 years. So within the period of 10 years, right, those fraudulent promoters cannot be appointed as directors. And finally, a corporation cannot be appointed as a director except a representative of that corporation is sent and appointed to the board for a given period. Okay, so let's continue. Also, on the issue of directors, the duties of directors are pretty set in common. So you don't generate duties. They have duties of which, if they fail to do, they can be held liable. Duty to act in good faith, duty of care and skill, duty to disclose personal interest to the company, where there's going to be um, a conflict between personal and corporate interest. Although primarily they actually have a duty to avoid conflict of interest, so they should avoid conflict of interest. But wherever it is likely to occur, can't be avoided. Disclosure. Directors also have a duty not to make secret profits. They have a duty to keep account books of the company and duty to exercise accountability to shareholders and relevant stakeholders. You can find these details in sections 305, 306, and 308 of CAMA. Alright, having unpacked that on directors, let's move on to accounting records and financial statements. That's the financial guardrails and sector specific rigor. Now, every company must keep accounting records, and CAMA specifies exactly what should be in the records. So, if you check section 374 of CAMA, you see that the accounting records should contain entries from day to day of all sums of money received and expended by the company, record of the assets and liabilities of the company, and such other requirements as can be found in section 374 of CAMA, as I said earlier. Now, the accounting records are also used to help prepare the financial statements. Section 377 of CAMA says that um, the director shall, in respect of each year of the company, prepare a financial statement for the year. Now, further, CAMA specifies again what should be the financial statements. Although there are slight distinctions between what should be in the financial statements of a public company and that of a private company. So if you don't keep your records properly, like poor bookkeeping, if you rely on informal records or you don't conform with the stipulated entries of both the accounting records and the financial statements, you'll be making mistakes that could negatively impact your company or your business. Okay. Um, Now, the most, should I say, perhaps the most violated compliance obligation by most companies, the issue of annual returns, right? So, basically, a lot has been said on this. As a matter of fact, a webinar was held recently where a secretaries really, would I say, decomposed the issue of annual returns. Now, as I said earlier, it's very likely the most common compliance breach in Nigeria because it's one of the key compliance obligations that are usually overlooked by companies. In section 417, CAMA makes it mandatory for companies to file their annual returns yearly, excluding the year of incorporation. That is, in the year that you incorporate your company, you do not need to file your annual returns. Prompt filing of annual returns is an important way to notify CAC that your business is a going concern. So that your business had no activity in a particular year is not an excuse to not file your annual returns. You should still file because the point of filing annual returns is basically to notify CAC that my business is still in existence. Do you understand? If you do not file your annual returns promptly or do not file at all, it may result in penal section sanctions against not just the company but the directors and the principal officers of the company. Further, It can lead to removal of the company's name from the register of companies, or yeah, basically, or make the status of the company on the CAC portal appear as inactive, and that will negatively impact the company. Because imagine you do not conduct business in a certain year, and because of that, you fail to file your annual returns. Then 2 years after, you want to conduct business with the name of your company that you refuse to file annual returns for the past 2 years, and then you try to do legitimate business, and then your business partner decides to go and check the to verify the validity of your company on CAC, and they see inactive, you've already lost that business opportunity because no one wants to do business with you. They will be scared. Do you understand? So you should file your annual returns for you. It's for your own good. All right. So let's move on. Now, if you can just check the slide that is before you, you would see that the whole compliance, should I say, cycle is not really something that is just standing in the air. One thing is connected to the other. For instance, today we spoke about accounting records, we spoke about financial statements, right? Your accounting records will help you prepare your financial statements. You will present your financial statements along with your auditor's report and some other things at your annual general meeting, right? These things will also enable the filing of your annual return, which guarantees you active CAC status. Of course, now I didn't bring in all the compliance obligations we have earlier discussed into this table. I just try to help us see how some things are connected, but every compliance obligation matters, not just the ones that you can see. Do you understand? So the list that I have um, provided us with so far is really not exhaustive. If you see the size of Companies and Allied Matters Act 2020 is big, right? Because there's a lot, and the entire book is basically telling you how CAC expects you to, I wouldn't say run your company, but comply with in order to run your company. Because a company is very, very important in the financial scheme of things in a nation. Do you understand? So that's why CAC has to regulate how companies, how they communicate their existence and keep their records, and so on and so forth. So, like I said, this is not exhaustive, but these are some of the basic compliance obligations that a lot of business owners or companies neglect and can mar the existence of their business in the long run. So, basically, yeah, there are penalties that accumulate over time when you don't do these things. As I was speaking, you'll have heard me say, "Oh, the company will be liable to penalties, the directors, the principal officers of the company." When you look at how these penalties are outlined in the CAC, you will see, oh, a fine of so 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 for reaching this particular compliance obligation, and another amount will accrue for each day that you breach the obligation. You don't want to end your company by paying off CAC debts. You don't want that for yourself. So CAC penalties are not one-off tickets. They accumulate over time. They compound daily in most cases, and that will drain your operational profits. You might end up losing your company to um, lack of funds because you are now paying heavy CAC debts, right? Also, um, you're liable personally. I said this earlier that directors will be liable, principal officers will be liable. So although the company is a legal entity of its own, but when some of these compliance obligations are breached, not just the company bears the brunt, the officers of the company, directors of the company will also bear the brunt, and that's piercing the corporate veil, right? And the ultimate sanction is administrative dissolution. Like I said earlier, CAC can strike the company's name from the register of companies and the business will cease to legally exist. Okay, we are gradually coming to the end. I think I should say at this point that if so far you have had any questions, please kindly drop your questions in the comment section on the YouTube, and then I will be able to attend to your questions, right? Okay. So moving on, how do you survive, right? So I've mentioned a lot of the compliance obligations. I've mentioned that there are penalties, and if you're a business owner here, it might sound like a lot, right? Because like I said, it's not exhaustive. There's still a lot more. So in your head, you might be like, okay, how do I ensure that I don't offend CAC and they don't come after me or after my company? First of all, I advise you to document everything. Keep proper records, your meetings, your company funds. Keep record of every single thing because this can help you maintain accurate registers. If you keep proper records of monies that you spend, you can produce proper accounting records, you can produce proper financial statements. So it is important for you to keep proper records. Also, it is important that you maintain a compliance calendar. That's very important. So you know the dates, right? Oh, I have to hold my annual general meetings within 15 months from the lapse of one. Set out your calendar. Oh, within the next 15 months we have to hold the next annual general meeting, and many other requirements like that. Map out your have a company calendar. Map out, oh, we have to file our annual returns when. Map it out to your calendar and ensure that by then you file. Just basically maintain a compliance calendar. Then also it is important that you understand that your company is a legal entity that stands distinct from you. This is very important because a lot of business owners mix personal and company funds. That's not wise because it would make it difficult for you to keep proper records. So don't mix personal and company funds. Your company has its own money. You have your own money. Operate separately. Do you understand? Also, you should conduct periodic internal audits. Before CAC comes for you, come for yourself. Check what have we not done. Do you understand? Don't wait for CAC to fish you out. Be proactive and audit your own statutory books and portal status. Very importantly, engage professional guidance. There isn't I don't think you might have a solid business idea going on for your company, quite all right. You might know exactly what to do, or you have the maybe for instance you run a logistics company, you have the perfect idea on how you're going to move your company to the next stage. But you can't step into the position of a legal advisor or a compliance officer. There's a place that they're supposed to occupy in your company. You can't step into that position. You can't always keep in your head or disturb yourself with compliance obligations they are supposed to keep. Matter of fact, you might not even understand them completely. So the importance of engaging a professional or getting a legal advisor to ensure that you're keeping up to date with this compliance obligation cannot be overemphasized. The expertise and time required to keep your company out of the water with compliance requirements are commodities you very likely do not have by yourself. So it is important that you approach or rather engage a professional before your bright business ideas are forced to close down. Why? Because you're not complying with CAC and CAC has not come for you and you don't know what to do. That's not what I'm saying. So it's very important that you um, engage professional guidance. I intentionally left this point for the last because it is very cogent. But I mean, most of the other things I even said, maintaining a compliance calendar, ensuring that you're doing periodic audits. If you want to conduct periodic audits, you don't even know what to conduct the periodic audits on. Why? It's not like you study law. So yeah, basically, it's very important that you engage a professional. Okay, so finally, I would just like to tell us that business success in Nigeria today is not just about profits, right? It is about structure, accountability, and compliance, right? The business thrive and those with compliance not as a cost, but as a strategic advantage. All right, and I'll just briefly like to tell us that A secretaries will help businesses stay compliant, structured, and legally protected. Thank you very much for coming to today's webinar. I just want to briefly find out if we have any questions. Just give me a second. Okay, so feedback I have is I have no questions. Thank you very much once again. So basically, just to summarize everything that I just said, is that upon incorporation of your company, okay, incorporation might be good. Upon registering your company with CAC, after you get your CAC certificate, obligation not end there. The survival of your company does not end there. After that, it is important that you comply with some requirements that the Companies and Allied Matters Act 2020 says you should comply with. And it is mandatory, it's not suggestive, because if you don't, it can it can cause the legal validity of your company to cease, and then it will be pointless that you registered your company in the first place, and you don't want to start running your scatter. So yes, the summary of what I've basically said is that incorporation is just the beginning of the journey when you start a business. There is a long other things that you do yearly basically, and it is important that you comply with these things, and never forget that you shouldn't try to be compliant on your own. Engage a legal professional. The cost of it is way less, is way convenient rather, compared to the disadvantage when you do not comply and you now have to face the penalties. Thank you very much once again. We'll see you next time on our webinar. Please do stay tuned to our channel so that you can get and follow us on our social media platform so that you can get updates about upcoming webinars that will be very, very insightful, educative, and enlightening like this. Thank you very much. Bye.